Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice, but I will tell you that nothing will prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. This episode's topic is UNUM, and UNUM, much like other disability carriers, has a history of arbitrarily denying disability claims. If you've got a policy through UNUM, this is the episode for you, because this will give you insight as to the games that UNUM will play with various types of claim. I'm going to be telling you about 4 stories that I think illustrate the games that UNUM play. But if you don't have a UNUM disability policy, don't tune out. These are also games that other disability carriers will play. It's in the Disability Carrier Denial Handbook. First, I'm going to start with talking about the 5 reasons that UNUM used to justify denying a long-term disability claim by an emergency room physician with breast cancer. Second, I'm going to talk about how the lack of diagnosis and the ability to work in other medical facilities doomed an urgent care physician's claim for UNUM disability benefits based on multiple chemical sensitivity. Thirdly, I'm going to talk about a vertebral compression fracture and wedging claim that was denied by UNUM and ultimately overturned by a federal judge. And last, I'm going to talk about UNUM's claim that a policyholder's back pain was out of proportion to evidence of radiculopathy on exam was reversed by a federal judge. Let's take a break for a moment before we get into this exciting episode about UNUM.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. You ready to get started? I'm first going to talk about the 5 reasons that UNUM used to justify denying a long-term disability claim by an emergency room physician with breast cancer. Emergency room physicians are on the front line every day, dealing with at a high level of cognitive, emotional, and physical demands. So what does a disability carrier like UNUM do when the policyholder is diagnosed with stage 4 metastatic breast cancer? Often, UNUM will wrongfully deny a claim and force a physician into stressful and needless litigation. And it doesn't have to be a physician. They don't seem to have a lot of sympathy with breast cancer claims. And that's what happened in the case of Kaiserman versus UNUM Life. Now, Dr. Kaiserman, who was in the state of Washington, was an emergency room physician at Harborview Medical Center. She was diagnosed with stage 4 metastatic breast cancer. There's a 27% survival rate at 5 years. The cancer had metastasized to her liver and to her ribs. She took a full year of medical leave, and she underwent chemotherapy, a lumpectomy, hormone treatment, and even a liver ablation. A year later, with the approval of her oncologist, Dr. Kaiserman returned to work in the emergency room on a 50% schedule with no night shifts. I think that was amazing. Now, UNUM paid a year of residual disability benefits based on her reduced hours, and then terminated her benefits saying, you can now work full time. So what were the 5 reasons that UNUM gave to justify this claims denial? I find that they often will create reasons to justify claims denial, and this case is no exception. So UNUM first said that your emergency room physician job is a light duty job. Secondly, they said that the treating oncologist improperly created reasons to restrict Dr. Kaiserman to part-time work after the denial, notwithstanding the fact that UNUM had accepted the part-time restrictions assigned by the treating physician and had paid Dr. Kaiserman residual benefits. Talk about talking out of both sides of your mouth. Number 3, UNUM improperly argued that exercising, doing yoga, or vacationing with her family was inconsistent with her complaints of fatigue. UNUM improperly ignored the known side effects of treatment. And lastly, UNUM ignored the obvious immunological issues that arise with working in an emergency room setting, and certainly in the age of COVID. Fortunately, the federal judge threw out all these bogus reasons and found that Dr. Kaiserman was entitled to her UNUM benefits. But let's talk about the lessons that were learned in this case. And I think there are 5 lessons that were learned. First, it's not uncommon for disability carriers, including UNUM, to misclassify or mischaracterize your occupation. So don't be afraid to challenge that. Now, that will require that you or your lawyer hire a vocational evaluator. Secondly, you want to make sure that your medical records and the attending physician statement forms your doctor completes document your symptoms, how those symptoms interfere with the material and substantial duties of your occupation, and why, for example, you can only work part-time. Thirdly, I think you have to explain why personal activity isn't the same as your occupational duties and the price that you pay for those personal activities. Number 4, you should document the side effects of the treatment and give examples of how the side effects may impact the material and substantial duties of your occupation. So, for example, in breast cancer cases, it's not uncommon to go through chemotherapy and radiation therapy. There can be serious side effects from that treatment, including fatigue, but you can see cases of tingling and numbness in people's fingers and hands. Now, if you're in the emergency room and you have difficulty using your hands, that can be a big problem. And lastly, you should get an affidavit from your oncologist about your immunological issues with supporting medical literature that explains why you have these immunological issues and why working in a particular environment is inappropriate for you. All right. I hope you have learned the 5 reasons that disability carriers like UNUM will use to justify a claims denial, and more importantly, the 5 lessons learned from this case. Let's take a break. Welcome back to Winning Isn't Easy. Let's talk about how the lack of a diagnosis and ability to work in other medical facilities dooms an urgent care physician's claim for UNUM disability benefits because of multiple chemical sensitivity. A disabled policyholder or plan beneficiary has the burden to prove that they're disabled as required by the terms of the policy or plan. And I'll be frank, that can be very hard to do in a multiple chemical sensitivity claim. What is multiple chemical sensitivity? Well, it's an unrecognized and controversial diagnosis. It's characterized by chronic symptoms attributed to an exposure to low levels of commonly used chemicals. Unfortunately, the symptoms are vague, they're nonspecific, and they can include things such as fatigue, headaches, nauseousness, and dizziness. There are several theories that explain the cause of multiple chemical sensitivity, and that can include allergies and even neurobiologic sensitization. Nonetheless, there are terms that in a disability policy or plan that are going to be in play in a MCS claim. And these policy or plan terms can make it even more difficult to get your disability benefits. Let's start out with a common definition of disability. It's the inability to perform the material and substantial duties of your regular occupation because of sickness or injury. Now, this definition, in my opinion, has 2 key terms. The first term is material and substantial duties, and the second is sickness. A disability carrier is going to start their analysis of the claim by determining whether you have a sickness, which is commonly defined as an illness or disease. Now, continuing on this line of thought, disability carriers will dispute the diagnosis of multiple chemical sensitivity as not even existing, but certainly not being the equivalent of an illness or a disease. It can be particularly hard to prove that one has an illness such as sick building syndrome or multiple chemical sensitivity. Often there aren't any objective findings for the physical reaction to workplace exposures. You could be exposed to cleaning agents, fragrances, chemical irritants, sanitizers, pesticides. And I will tell you that's a particular problem because I happen to be allergic to substances like colognes and certain types of detergents. When tested by my allergist, my testing is normal. But if someone comes into my office wearing perfume I can lose my voice. In fact, it's so bad, we tell people not to come into my office if they are wearing perfumes, colognes, or that sort of thing. The problem, of course, is that multiple chemical sensitivity isn't even recognized as an illness by some physicians, and many disability insurance companies have position papers that dispute the legitimacy of MCS and the diagnosis of MCS. Now, as I've said, one of their first lines of defense is going to be you don't meet the policy definition of sickness or illness. But the second line of defense is the inability to perform the vocational demands of your occupation. What the carrier says is, look, you've got the burden to prove that you don't have the capacity to perform the material and substantial duties of your occupation. And we're going to question whether you could perform those occupational duties with a different employer in an environment without the exposure to the chemical irritants, or whether there is some other reason why you can't work in a different kind of environment. Now, if they can show that you can work in a different environment, that maybe a different location, a different employer, they're probably going to deny the claim. And that's going to be particularly true if the policy definition of occupation is the inability to perform your occupation as it's normally performed in the national economy, instead of how you perform it for a specific employer or a specific location. Because generally, that's the problem. It's generally something that's at the workplace environment that is a trigger. And if this definition is in play, you're going to have a much more difficult time in getting your benefits. The disability carrier or the plan administrator is going to take the position that it doesn't matter what you're exposed to at your employer's place of business or your reaction to that environment, because that's not the standard definition of occupation. In other words, the work environment is not material and substantial to the duties performed in your occupation. Now, the plan or policy may not require, under the definition of occupation, that you perform your duties at a particular location or in a specific environment. And if that's the case, the courts are going to bite on this argument that disability carriers make, and they will uphold a denial of an MCS claim. That's exactly what happened in the case of McFarland versus Unum Life. And this is another Washington state case. McFarland worked as an urgent care physician, rotating among various facilities. He had specific reactions at just one of their medical facilities. His physicians didn't really give him a diagnosis, and even went so far to say that, look, he could practice medicine so long as he avoided exposure to chemical irritants. He filed a claim, and of course, Unum denied the claim on the basis that there was no diagnosis and no proof that he was unable to perform his occupation as that term was defined in the plan. Of course, this case ended up in court, and the judge upheld denial on the basis that McFarland could, and in fact did, practice medicine so long as he limited his exposure to chemical irritants and avoided certain facilities. The judge also noted that the building in question had been tested for air quality in the past, and that didn't help McFarland's case. So you can see how difficult chemical sensitivity cases or sick building syndrome cases can be. You've got to look to the terms of the policy, the definition of sickness or injury, and certainly the definition of occupation. Let's take a break.